Well, welcome and welcome back to those viewers who continue to tune in to the TuckerAllen Town Hall that we bring to you. I'm Scott Trout, and as usual, I'll be moderating for you today and this afternoon. Keep in mind that obviously in this town hall, we want to hear your questions. We want to try to give you some answers, but keep in mind that we don't want this to establish a attorney-client relationship. Obviously, our guests in our panel today are going to be providing some tips, some ideas, and some questions that will be answered, but certainly can't give you legal advice as it relates to your situation. But we'll try to guide you down the right path as we take your questions, and there'll be an opportunity for you to do that in the second half of our town hall today. So make sure to utilize the Q&A section to submit your questions if you have them as you go along, and we can make sure to get to those questions today. We have some that have come in, and we'll reach those later on in the second half today. Obviously, you can also submit those questions to TuckerAllen.com/questions. And we can address those, obviously, in our Facebook Live segment that we'll be doing every Friday at 1 o'clock Central Time. If you haven't tuned in, tomorrow we'll be doing another edition of TuckerAllen Live on Facebook. 15 minutes. It'll be a power-packed 15 minutes on topics that are of interest to you. So follow our social media page. Tune in tomorrow, 1 o'clock Central Time, 15 minutes of your time. We'll answer some questions. We'll talk about a very brief topic. And we'll be doing that every Friday. So if you have questions you don't want to submit today, again, you can go to TuckerAllen.com/questions, and we'll submit those and get those answered to you on those Fridays during TuckerAllen Live on Facebook. If you have a question, you want to set up a consultation, you certainly give us a call at 866-335-3375. So let's get to our panel today. As usual, we're joined by our TuckerAllen attorneys from, let's go to Missy in St. Charles, St. Louis area. Missy, welcome again.
Hi, Scott. As you mentioned, my name is Missy Manning, and I'm an attorney in our Kirkwood and our St. Charles locations, and I'm certified to practice law in the state of Missouri.
Good to have you again, Missy. Now let's go to our Illinois metro area. We've got Teresa Yao. Welcome back, Teresa.
Thanks for having me again, Scott. I am an attorney in our Edwardsville and Kirkwood offices, and I am licensed to practice in Missouri and Illinois.
Thanks, Teresa. Rounding out the panel with our TuckerAllen attorneys, Kevin Mason up in Kansas City and Independence. Welcome, Kevin.
Hi, Scott. As you said, my name is Kevin, and I am licensed to practice in the state of Missouri, and I practice here on the Missouri side of KC.
Thanks, Kevin. Well, again, make sure if you've got questions, I know you will. I know I have them. We're talking about trust distributions today. I was talking to the panel off camera, off audio, and I'm like, I have no idea what you're talking about. And I know I have plenty of questions, so I'm sure you will as well. Keep in mind, during COVID-19, TuckerAllen's doing consultations via Zoom, via telephone, or WebEx, any type of video, FaceTime. You can take advantage of that. You just want to give them a call. You can actually go to the website, TuckerAllen.com. Check it out. You can actually submit a request for a consult and schedule it right on the website. Don't even have to have a communication with an employee over at TuckerAllen. So before we get to trust distributions, which is the topic for today's town hall, let's take a real quick break. We'll be right back.
I wasn't really avoiding it, but I'm pretty good at procrastinating. I needed a trust. When I found TuckerAllen, all our questions were answered, all of our fears allayed.
You want your wishes in place, so there's no guessing, no stress on the children.
Basically, they talk about what you need, what's important to you. It was more conversational, really very simple.
All right, welcome back. I've been talking about this for a number of months during the pandemic, and as we just heard on the commercial break, it really is, if not now, when, and we want to make it easy, and that's why we do these virtual town halls, is to answer your questions and try to break down what appears to be a complicated process into something where we can speak normal speak and not lawyer speak, but obviously with trust distribution. I don't know, maybe I want to find out more about it. So Missy, let's talk about it. What is it, and why do I even care about this topic?
All right, so trust distribution is the process of paying out your money to your children or other beneficiaries after you've passed on. So basically, it's just different ways that you get the money to your kids from the trustee after you've passed.
So you got to have a trust in place to begin with, I imagine.
Mhm.
Yes, that's
Yep,
kind of
yep.
the what we would call the condition precedent, the first step in order to kind of get from point A to point B. Got to get it in place. And I know I'm a client, and I've said this before, of TuckerAllen, and the question becomes, you take those steps to create the trust, and there's so many questions you probably don't know what questions to ask, and that's even if you've had it done, this is a good point to start with as we talk about trust distribution. And similarly, Teresa, there's something called outright distribution. What is that?
Yeah, so I think now we're getting into the meat of trust distribution where we talk about different types of distributions from a trust. Outright really is the most straightforward, efficient type of distribution. I know a lot of times when clients come into our office, ease and convenience is kind of at the top of their priority list. They ask, what's the easiest way for my loved one to handle things if something were to happen to me? And then if that's their priority, outright probably makes the most sense for them. Because what it does essentially is just saying, hey, we set an age of inheritance, and if a beneficiary is that age or older, then at that point, if something happens to you, the beneficiary can get that share in one lump sum.
I'm going to come back to you, Teresa, real quickly. Missy, though, when we talk about this outright distribution, that doesn't mean that a client who's watching or listening right now, they don't have to choose an outright. Could they choose something different where it's over time? If in their trust, can they be very creative and design their trust that doesn't have to follow an outright?
Absolutely. It's completely flexible. This is probably our most popular option, but we do have different ways of doing it periodically, or sprinkling trusts, which Kevin, I'm sure we'll talk about more later, and then keeping the money in the trust forever so you have greater control. But this is just one way to do it. That's our most popular.
So Teresa, as we think about there are multiple ways, if a client or someone's watching right now and they're thinking, okay, that's kind of what I want to do, what are the pros of selecting an outright distribution in your trust?
Yeah, so I think kind of touched on this earlier, but the biggest benefit of an outright distribution is that it's very streamlined, it's the most efficient, and it really requires very little administrative burden or cost on behalf of the trustee, because normally it can be wrapped up in a year, it can be really fast. And the cons of an outright is that because you are just saying, hey, beneficiary, if you're this age or older, then you get one lump sum. It does mean that you get a little less control about how your assets are going to be used by your beneficiaries.
So practically speaking, we've talked, what is it? How does it work? How does it apply? I mean, I know that you see certain age limit, like 25, maybe you can talk to everyone watching. How does it, applied, and what are its implications as you go through an outright distribution?
Yeah, so practically speaking, how it works is with the age of inheritance, and we normally say age 25, that's the default. Depending on a client's situation or their family, they can certainly change that number to be younger or older. We just say 25 because normally kids are done with college, maybe even some grad school at that point. So it's just a relatively safe number to act as the default. And it's just saying, okay, if the kid is age 25 or older, then at that point, they have a right to withdraw 100% of those funds. If they're below age 25 and something were to happen to the parents, that means that the trustee can hold on to these assets inside the trust and of course have to use these assets for the benefit of the beneficiaries. And the standard by which the trustee has to operate is to use it for the beneficiaries' health, education, support, and maintenance.
So if the trustee is using it for a child or children under 25, they can pay it over time. They can pay it in I guess I would say lump amounts for their benefit, right? Not to the child because they're under the age. So it doesn't sit there and they can't use it. It's that they can use it as long as it's for the benefit of the children or child.
Yes, exactly. So, for example, if something happens to the parents, but the kid needs to go to college, the trustee can still access those trust assets to pay for the beneficiary's college tuition.
And I know we've talked about this before about the importance of selecting the right trustee. Maybe someone who, you've had conversations with who, I may go to a friend and say, hey, Bob, if Jill and I go, here's what I want you to do. I've got 3 kids now under 25, 2 are past that, and or 4. And so the point is that this is what I want you to take care of them. That's the conversation you want to have, right?
Yeah, absolutely. So this is not a job to take lightly. When you're appointed as a trustee, or if you're appointing somebody as a trustee, they're managing, ideally when you have a trust, most, if not all of your assets are titled along with your trust. So this is the person that's going to be managing everything that you've titled with your trust. So it's somebody that is savvy, has integrity, and really understands your priorities for your family.
So Kevin, I know we've talked about it, this outright. There's another option, periodic. What is that? Can you kind of give us a give it to people in an example so they kind of understand it?
Sure. So periodic, whenever we're distributing the trust assets in that way, generally what we're talking about would be that the grantor of the trust, the person that created the trust, they want to have the assets distributed at 3 specific times, let's say. So they have a beneficiary, their child. They want to give their child money whenever they're 25, 30, and then 35. So kind of what that would look like on our end would be that we would set up this trust document to where 1/3 of the trust assets would go to this beneficiary whenever they turn 25. So then whenever they turned 30, we would take 1/2 of the remaining trust assets and give it to them. And then whenever they were 35, they would get the remainder. And kind of the effect of that is that it creates kind of a 1/3, 1/3, 1/3 of the trust assets at 25, 30, and 35.
Got it. So I want to hear kind of what you think the pros are and the cons, but as I was listening to you, I'm thinking I always try to put myself in the shoes of people watching because I feel like them. I don't know a lot about this area, and I learn as much, I hope, as they are by talking with the 3 of you. I'm thinking of my kids, and I'm thinking of COVID, and I'm thinking, I always worry a little bit about it. I've got my trust in place, and I have to worry about funding it, and that's a different situation. I've mentioned that many times. But as I think about it with my kids, I've got, 2 in high school, and I'm thinking, of course, I wouldn't want them to get, if my wife and I, passed, I wouldn't want them to get all this money. They're not mature enough. They don't understand it.
Mm-hmm.
But maybe talk about the pros and then talk about the cons and, relate to people that are trying to figure out what they should be doing. Should they do outright or periodic?
Sure. So kind of just like you were saying, maybe the most obvious pro of having this periodic distribution is that it doesn't give the beneficiaries all of the trust assets at once. So if you're thinking, oh, I'm not sure at 25 if they're, or 22, whatever the age that this person decides, like Teresa was saying, most often it's 25. If you're saying, oh, at 25, they are not going to be mature enough to handle this amount of assets that they're going to be given from the trust, and maybe you want to split it up across 3 separate distributions so they're not getting all of these assets just at one time. And then kind of the con would maybe be that same thing again, where it's that they aren't getting all of the assets right away. And who knows, but a lot of people, whenever they're in their late 20s, they're kind of getting their life started. They've been working for a few years, they're getting married, they're buying homes, maybe having children, and it would be nice to have that money, those extra assets from the trust.
Yeah, it makes sense. My daughter just got married at the end of the year, and you think she's 22. And I'm thinking, yeah, you're right. Maybe they want to buy a house. If I were to go, or my wife were in the same accident, whatever it would be nice to be able to consider that. And I think maybe that's the question. I'm going to jump to Missy, and I'll come back to Kevin. Can you do a combination of outright and periodic, or can you break it up, or is it better suggested to follow one path in your trust?
Generally, you choose just one of these distribution methods. Yeah,
it gets it's complicated, right? Because you don't want to break it up by child, right?
That could be perceived as unfair, but you certainly could have it different for different children. Your children better than us. So if you think one's better to be outright and one's better to be periodic, you can certainly do it like that.
Yeah. Let me ask you real quickly, Missy, because I know Becca has asked a question, and rather than jumping off the topic and trying to circle back, Becca's asking, do the assets automatically get distributed to the children at the designated age, or does the child actually need to know that the trust exists and seek distribution?
So the trust is required to let the beneficiaries know that the trust exists, and they're required to give them a copy of the trust. So presumably they have a copy of the trust. Whether they read it or not is kind of up to the child. And then it also depends upon what it says in your trust. Some of them say at this age, the trustee must distribute it to the child. Some of them also say that the child must request it from the trustee to get that money. So it kind of depends upon how you set things up and how you want things to work. So maybe if you have kind of an oblivious child, you want to take advantage of that, we can certainly do that. One thing I did want to mention, one of the cons for having a prolonged distribution period is that there are tax implications and other financial implications for having a trustee serving for such a long period of time. So in Kevin's example, they would be serving for at least 10 years, assuming all of the kids are 25 and over. And you got to pay the trustee. Sometimes trustees will waive their fees, but most of the time you got to pay them. And then you also have trust tax returns that have to be filed every single year. So you got to pay a CPA to do a trust tax return for you. And also there might be trust taxes if the money isn't all coming out. So that's another thing where you have to try and make certain that you're working with a CPA to get the most minimal tax consequences possible.
So Kevin, as we kind of talk through it, there are pitfalls for the trustee even as you think through this, right? And that they may, it's a longer period of time. They have to be on top of their game. They have to find the children. They have to watch the money moreover. Isn't that right? I mean, practically speaking, the implications are perhaps that it's worse for the trustee on this type of distribution.
Sure. So there's a lot more going on for the trustee in this type of distribution just because it is occurring over a decade or longer. And there's a lot more time for the trustee to just screw something up. I know that you and we had spoken about fiduciary duties a little while ago, and there's fiduciary duties that these trustees have that they have to abide by. So one of them will be like the duty to inform or things like that. There's just all sorts of duties that the trustee has to uphold for this 10+ year time frame. And then another thing that I would just like to toss in here again with trustees in this situation, it might not be the best to just choose your close friend or your cousin or your sister or something like that, just because this is occurring over a 10+ year span. And you might want someone who's a professional, someone who does this for a living. So this would be a good time, or if you were doing this, it would be a good to speak to a professional. So go to a trust company, get somebody who knows what they're doing to distribute and administer this trust for you.
Yeah, I mean, it makes sense as I think about it as I get older and the trustee I've selected is my age. I mean, goodness, if I'm 80 and I die, do I really want a bunch of 80-year-olds as my trustees, who are likely to perhaps pass? I don't know. And maybe they're not all with it. It makes me really rethink it. And there are people watching right now who are thinking, well, I've got a trust package and maybe I don't need that trustee. We've talked about this before, about how the simplicity of perhaps shuffling the deck on trustees. I mean, that's easy to do, obviously. It's something to think about. And as you point out, Kevin, I think which is appropriate is to really put some thought and have a conversation with your attorney about really the pitfalls of selecting that trustee. Because the default for me when I was doing it is pick someone I know, pick someone I trust. And I wasn't thinking about their age or thinking about the complications or thinking about what you had just pointed out. But I do think that that's probably something to really consider. So what I'm taking away, Kevin, and maybe your thoughts, is that maybe this isn't the best idea for this type of distribution, absent some really good reason, right?
Sure, I would agree with that. I think if you have a good reason, if you have a beneficiary that if you give them this big lump sum, that they're going to blow it right away, but you think maybe if they have some time to learn how to manage the money and spend it by the time they're reach that last payment of assets, then they could handle it. Then maybe this would be a good situation. But absent a really good reason, I'm not sure that this is the best for very many situations.
Yeah. All right, Teresa, sprinkling. It's an interesting word. I think of a donut with little sprinkles, right? But sprinkling distribution, what is that?
It's funny because I think of sprinkler, but it's just whatever form of sprinkles we take.
Yeah.
But essentially a sprinkling distribution is the most common for families with multiple kids and multiple minor kids. How it works is it doesn't require that the trustee has to distribute to the beneficiaries in equal shares. The way it works is it's saying, okay, if something happens to the parents, then the trust is a sprinkling trust, and it only terminates when the youngest child reaches a certain age. before the youngest reaches a certain age, let's just say 30. So before age 30 for the youngest child, the trustee has pretty much full discretion to use the trust assets across the different kids for depending on the needs that the kids would have. The kind of main reason why people will want this is just saying, hey, I don't know what my kids are really different. I don't know what their needs will be, 15, 20 years down the road. And I want to make sure that the assets are used most equitably depending on their situation. And I want my trustee to have that discretion to make that judgment call.
Yeah, I'm really, as I think, I try to apply, as I said, my life to, as I'm watching, as if I'm just kind of a viewer here. I've got 5 kids, 10 years top to bottom. I can imagine my oldest would just lose a lid if he's thinking, I got to wait till I'm 40 to get this asset. So talk about the pros and cons here. I know people are, that's the kind of questions I'm trying to think in a non-legal question. So what would they be? Why would I do it? What are the advantages here?
So I think that is a big reason why people choose to not do it, because if there's a big age difference between your oldest and your youngest, it's oftentimes not very fair to the oldest child. But the pros of a sprinkling distribution is that it does build in a lot more flexibility across different kids. Maybe a child is a doctor and the other one is a teacher, and maybe the teacher does just need more financial assistance from the parents from the trust, and it just allows for that judgment call to be made by the trustee later on. The cons, though, is really the trustee has the ultimate control. The trustee, before the youngest turns at a certain age, the trustee really gets to decide what happens to those assets. I think another potential con is similar to what you were saying. The oldest has to wait the longest. Let's just say one child decides to go to a really private, expensive college, and then the other child works really hard and gets like a full ride scholarship to another university. And is it really fair that the child who didn't get the scholarship is kind of eating up all the assets inside the trust, and then the child with the scholarship kind of just gets less? So those are considerations to take in.
I mean, I think as we talk through this, what really continues to jump out at me is every month and every Friday we have a topic. One size doesn't fit all, right, Teresa? I mean, this is the beauty, I think, of this law that I'm so unfamiliar with, is that you can tailor what matters, not just to you, but like, as you suggest, maybe there's one child who has, more needs financially, whatever it may be. So it may make more sense in that regard to do it. And I think that's the wonderful conversation that everyone should be having is, if you're with an attorney who just says, here's a will, here's a trust, this is how everyone does it, you do it. You got to ask questions. That makes you really pause, right?
Yeah, so I think the main takeaway, hopefully, from today is here are all the different options, and we really encourage you to speak with an attorney to share your situation, what your kids are like, and we set your trust up in a way that makes the most sense for your situation.
Yeah. So as we continue, we're getting close to the kind of the midway part. We want to make sure we get to your questions that you have. Submit those in the Q&A section. We'll get those today. We have some coming in. I know I took Becca's earlier, and Dennis has got one. Missy, I'm going to come to you and talk about a distribution in share trusts, but I want to see if I'm going to throw you this question from Dennis, just because I think it's appropriate, a little bit off topic, but it's a good question. So it's long, so bear with me, but I think we get to the point. Dennis's brother passed away with no will or trust. He had no spouse, and the parents had already passed away. By default, his estate passed to his siblings, and there were 4. And Dennis is the trustee for the estate. Everything has been distributed except an annuity that still happens every 5 years. And he splits it equally between the 4. My question for Dennis is really this, is what happens if one of the 4 siblings dies? Can he just distribute it equally? The process really, it gets complicated, obviously, when you don't have a will or a trust, because then you got to look at the statutes and figure out the way to do it. But obviously Dennis needs to get more advice by coming in. And I think he plans to do that, but what do you say?
All right, well, a lot of it kind of depends upon where you are and how things are set up. But generally speaking, if one of the siblings passes away but has living children of their own, that person's 1/4 share should pass to their children. However, if they don't have living children, then the other 3 will just take a 1/3 share.
Got it. I mean, I think that's the point with, is to ensure you don't want to get in a situation like this, where Dennis has questions. Dennis has to, you know, stress out about it and go ask a lawyer, what do I do? Because as we're talking about these very complicated things about the sprinkle and the district, you know, the, you know, periodic and those things, it's already there in the trust. You're, as a trustee, you have the direction, you know exactly what you're supposed to be doing. So I think that's a good point. So let's go back to it. Hopefully, Dennis, we got your question answered. If not, we'd love to have a chat with you. You can do it via Zoom, or you can come on in. You can go to the website and schedule a consultation in any of the offices that we have. So, Missy, let's talk about distribution in share trusts. What is that?
Okay, so sometimes they're called separate share trusts or lifetime trusts. So instead of writing a check to a beneficiary, the money that your family members will receive stays in trust forever. It's called a little separate sub-trust. It's not the main trust, so it kind of splits out. Let's say that you have 2 kids and you pass away and you're going to keep their shares in lifetime trust for them. So there's going to be 2 trusts set up, one for each child, and that money is going to sit in that trust forever until they pass away. And then at that point, usually you say that it'll pass on to their kids or something else like that.
So why would I go to such lengths to do something like that? It seems a little more complicated. Why would I do it?
It is much more complicated, but there are good reasons for it. So if the beneficiary is not very reliable with money due to mental health issues or addiction issues, or they're just not good with money in general, holding that money for them means that you have a lot more control over it and you can ensure that it's being used the way you want it to be used after you're gone. Also, some reasons why is they don't like the spouse. So they're worried about some spousal influence there. They want to make certain that the spouse doesn't get their hands on that money while they're still married or after they get divorced, or they've got creditors that are lined up. And so if they keep the money in the trust, the creditors can't get access to that money in the trust. If you have a lot of money, so if it's an amount of money that you're passing on where this person, a general person, isn't able to make really good financial decisions because it's just so much money, keeping it in trust for a long time is usually a better idea.
Yeah, no doubt. As you think about the large amount of money, I was just reading an article this morning about the impending changes to the taxable estate maximum that the incoming president is going to change. So keep an eye out for that and make sure that you consult with an attorney to ensure that your trust remains appropriate, considering that as we face new tax laws as it relates to what we know as the death tax. So anyway, speaking of tax, what are the implications of doing this distribution in share? Is there negatives and tax implications by doing that?
There can be. So if any income that the trust earns is not passed on to the beneficiaries, so they got $0 from the trust that year, the trust has to pay trust tax rates on that income. So if you have really nice investments and you're making over $600 a year, that's going to be taxed at a higher tax level than as if you passed it on to the beneficiaries. Also, you got to worry about paying the CPA to file those tax returns. You got to pay the trustee to manage the trust for you. Yeah, it ends up cutting into the assets a little bit, the amount of fees and taxes and administrative burden that goes on.
So are there trustee costs annually? Are there accountant costs for tax returns or CPA? I guess I assume it sounds like that would be a factor as a potential negative. Correct.
So I don't want to shoehorn any CPAs into how much it costs to do a trust tax return, but usually they run anywhere between $300 to $1,000. And then trustee fees are usually around 0.75% of the net value of the trust each year. It could be more than that, or it could be less than that. So what are the positives? I mean, I'm thinking, okay, this sounds interesting. What is the advantage of doing it this way? It provides a lot of security for your beneficiaries. It gives you a lot of control. If your beneficiary needs the help, I mean, it's worth it. Hopefully the amount of return on your investments will be offsetting all of these various fees that are racking up every single year. But if your beneficiary really can't manage that money themselves, then it's worth the additional cost and administrative burden. Yeah, especially in the market the way it was in the last really couple of years, crazy growth. I imagine it would be an advantage to that. But there's a term called trust busting. What is that? So this is something we try not to advertise a lot, but according to Missouri law, which recently changed, if the value of the trust is below $300,000, then by default, the trustee, or you can go to court and have the trust closed down and paid out to the beneficiary outright. So if you're looking at a lifetime distribution, there is potential that your beneficiary could go ahead and bust the trust and get that money. It's not something that we put in our documents that we make them aware of, and it's just an obscure part of Missouri law, but it does happen. So it's something to think about. If there's more than, less than $300,000 that's going to be in this person's lifetime trust, then it's something that you need to consider that this person may be able to gain access to those funds according to Missouri law.
And as you mentioned that the law recently changed, I'm just going to toss a question right back to you, Missy, and I think this is appropriate. We've talked about, I think it's the CARES Act that recently affected some provisions in trusts. It says, should trusts be adjusted over time? So if my kids are very young now, should I update the trust after they become adults? And talk a little bit about the program that TuckerAllen offers, the annual program that reviews that, because I think that's key when we're talking about reviewing trusts. So go ahead.
Absolutely. So I wouldn't just wait until they are all above the age of 18. I would look at it periodically every couple of years, because you name one person as guardian and we're looking 5 years down the road, that person may not be a good guardian anymore. Maybe they've gotten divorced. Maybe this child doesn't get along with this potential guardian. So I would recommend looking at it more frequently than that. But you should certainly update stuff after your kids become age 18, or if you have a different level of inheritance in mind, you're thinking age 25, maybe updating it then. Our company does a legacy protection program. So if you sign up for this program, you can make changes to your trust for free each year. So you can change your guardians, you can change your age of inheritance, you can change all of that stuff for free when you're signed up for this program. So that way it's very flexible if something happens in the future.
So in that program, the legacy protection program, when you come in or you set up a meeting, whether virtually, talking about law changes that may affect your trust, right? Something that could happen, right?
Absolutely. So if there's been a change in the law, we always update you. If you belong to this program, we meet with you about once a year to go over all of your choices and tell you, this has changed in the law. We had the Secure Act come out in January. This is who you have listed as your guardian. Do you still like these people? That way we make certain that all of your choices are still exactly how they should be and that you're fully up to date and compliant with the law.
Yeah, and that question's so appropriate. I remember we did a trust, my wife and I, 20 years ago, and it just sat on the shelf, collected dust and cobwebs. We never really thought about it. We didn't think about the changes, not only to our family, but the law. I mean, obviously the law drastically changed over that course of 20 years. Not only that, but the death tax amount, things that, maybe the ideas, things evolve. And I encourage everyone watching, find out more about that legacy protection program, because once you sign up for it, it's kind of like peace of mind. It can sit on the shelf, but you're reminded each year to, hey, let's just have a quick consultation, no charge. Let's talk about the changes. Maybe there's some trustee changes that you want to do that are included in the program at no cost. Because the last thing you want to do is kind of what I did. Take, fast forward 20 years, I completely had to overhaul my trust and do it again, rather than signing up for an annual program where you're making these tweaks at no additional cost. It's kind of moving you forward and keeping it intact. So I think that's something. Give TuckerAllen a call. It's a really amazing program. That's an annual program for clients. So now let's turn to our question and answer part of the town hall. We have questions continuing to come in. And so Teresa, let's go to you. I'm going to ask you this question here. If the children are under 18 and the person designated as the guardian is not the trustee, how should trust be set up to make sure the kids are taken care of financially?
Yeah, so that's actually built in most trusts. In our trust, we anticipate what if the kids are still minor children by the time the trust needs to be administered. We already kind of talked about under the age of inheritance, under age 25, the trustee can use those funds for college tuition, health, support, standards. But even if the trustee is not the same person as the guardian, that's okay. The guardian is mainly appointed to take care of like the personal needs, lifestyle, like take physical custody and care of the child or of the children. And certainly the trustee will work together with the guardian to provide for those needs for the minor kids.
Great. All right, Kevin. I have a trust with 3 beneficiaries. when I die, does each beneficiary take a death certificate to the financial institution and receive 1/3 of each stock and 1/3 of each mutual fund that I own? Or are they sold and each beneficiary gets 1/3 of the money?
Sure. So it kind of depends on what that beneficiary wants. So if the beneficiary tells the trustee that they want 1/3 of, I believe you had mentioned stock,
Mm-hmm.
and then they can get the certificate and they can get 1/3 of the stock. So that's generally not the way things are done, though. Much more common would be that the trustee is going to take all of those assets, the stocks or whatever it is, and they're going to sell those, and then they will split it up 1/3, 1/3, 1/3 from there.
Got it. Missy, Carla has a question. Going back to what we were talking about, having the ability to not have money available to a child's spouse. Carla says, I thought that if the trust is only in your child's name, that only the money that your child takes out of the trust is considered joint property and therefore available to their spouse, but only the withdrawn money. And that's kind of a question I don't know how to answer, but go ahead.
That's correct, Carla. Generally speaking, though, it kind of depends upon how the trust language is set up. But generally speaking, when the money is taken out of the trust and it's just in your son or daughter's name and not in their spouse's name, that money is theirs. However, the part that gets tricky is when they commingle it and they put it into a joint checking account. Or they use it for a family vacation or something like that, where it's no longer just their money, it becomes their money total. So having a trust set up in such a way to protect the child from the spouse, you can do a lot of things very creatively to protect it. So you can say that that child gets nothing if the trustee decides that, unless the trustee agrees that that's a good distribution. You can say that the trustee needs to make those payments directly, so there's no chance of it ever going into a joint account or for a joint thing. So maybe the trustee writes those checks themselves and pays it directly to the vendor instead of having it go to the child.
Mm-hmm. Great. Thanks, Missy. All right, Teresa, the question is this. As a single parent of 2 children, I understand a trust is more likely recommended. How do I determine how to set up a trust to ensure they're taken care of both physically and financially in the event of my death? And additionally, do all my benefits have to name the trust as the beneficiary?
Yeah, so for that first question, I think the bigger takeaway is how do I make sure that my kids are taken care of financially and physically? So I think that's why we do things in packages at TuckerAllen. So a trust can kind of really take care of the finances, right? Your trustee can, everything can avoid probate, and then your trustee can have access to take care of your kids. But that's why we also have wills. Wills are where you appoint guardians. So you can make sure that your kids are going physical custody to somebody that you trust. And like we said earlier, guardians can work with trustees to make sure that their lifestyle needs are taken care of, but their finances are also able to support those lifestyle needs. For that second question of do all of my assets have to have the trust as the beneficiary? Answer is most, but not all. If you have a spouse for your retirement accounts, we say, hey, have your spouse be the primary beneficiary and then the trust as the contingent beneficiary, just for the spousal rollover tax advantages. But for most other assets, yeah, we would recommend the trust to be the primary beneficiary on those.
Okay. If you've just joined us, obviously we're in our Q&A section. You too can ask questions by submitting them at the Q&A section here and using the Zoom technology. We'll get to those. So Kevin, question just came in. As the trustee of my parents' now deceased trust, am I required to file a tax return for their trust?
Sure. So you are going to be required to file a tax return for the trust. So it's form like 1041, something like that, I believe. Missy's nodding yes, so I got that one right. So it's form 1041, and every year you're going to be required to file that as long as there's $600 or more within that trust.
Okay, great. Missy, let's go to you. And this was a follow-up when I talked about busting the trust. Jane says, if a trustee busts a trust, do they still have to follow the spirit of the described distribution? Perhaps, for example, to split it X ways across X number of children?
Yeah, so if the trust says that the money is going to these 3 kids equally, and then they terminate the trust because it's below the $300,000 limit, you still have to send it to those 3 kids equally. You can't just do it in a different way. You still have to follow the trust, how the money is going to be paid out.
Regardless if it's busted, right?
Correct. The distribution method might be different, but the percentages and all that have to be the same.
Got it. I'll stay with you, Missy. What is the best way to rename a partnership interest so that my trust now owns it?
Sure. So that's a great thing to do, because going through probate with a business is always a absolutely terrible idea. It takes so long. It costs so much money. Every dollar in and out has to be accounted for. So you definitely want to get that LLP directed to your trust in some way. It's pretty complicated of a procedure because there's certain language we like to include, but generally speaking, there'll be a resolution that all of the partners have to sign off on, saying that we approve that these membership interests are going to go to this person or this trust upon this person's death. And then usually you would reissue membership certificates and update your appendix that says who owns what. Yep.
I know every time we talk about adding an asset, I want to get in the fetal position about funding your trust because I'm still struggling to do it. So is that something you all do, that someone could call TuckerAllen and say, okay, I got to get my partnership in the trust, or I got to fund some assets in the trust. Can you have TuckerAllen help you and get those things taken care of?
Yeah, so we charge a fee for that, but we're happy to help you out and do it for you. We fill out all the paperwork. All you have to do is sign on the line where we direct. Also, if you sign up for that legacy protection program, we do 2 free funding forms per year as well, included in that program. So if you've got more than 2 assets, you probably want to pay for funding. But if you've got just one thing that's really sticking out and is too hard for you, maybe signing up for that legacy protection program, it's one of those little bonus items we have in there.
So I'm staying with you. I know you're going to get dry mouth here, Missy, because you just mentioned legacy protection program. What's the fee? That was a question that just came in. How much is that?
The first year is free if you sign up for a new package. And every year after that, the fee is $2.99.
So they can call, and that includes a whole host of things every year. You just mentioned 2 assets funded within it, a meeting, I think you said, to review the trust, to make changes perhaps to trustees, minor changes like that. And then does it review for major law changes so that you may need to incorporate that? That's included in the legacy program, correct?
That is as well.
All right. So they can check that out on TuckerAllen.com or give Missy a call or get any of the attorneys, obviously. So let's go to Teresa. Who pays the taxes on the trust money if the kids are not old enough to file taxes?
So the trustee is the one paying that. So if any assets or income generated by the trustee is the one that's responsible for that.
And it's filed on behalf of the trust, right? So it comes out of the trust money and the trustee files it on behalf of the trust as a tax return.
So the tax
right?
return is for the trust, yeah.
Got it. Okay. So I'll stay with you, Teresa, since you answered that so quickly. What are the advantages or disadvantages of an IRA trust?
So an IRA trust is kind of like this trust where it receives the proceeds from the IRA. The advantages of it is that it's greater protections for any assets inside of a trust, kind of like what we were talking about earlier with the lifetime trust, the creditor protections. If assets are in the trust, then it's protected from that. And it also allows for accumulation. And I know right now with the Secure Act, accumulation trusts are something that's more of interest to people. Accumulation just means, hey, instead of having to take a distribution from the retirement account every year and taking it directly into the beneficiary's hands, the trust can kind of accumulate that over the years and maybe wait to a better year to distribute the accumulated amount to the designated beneficiary. Disadvantages to an IRA trust are obviously the cost of setting it up, and also the similar cons where we were talking about the longer you hold a trust open, there's also that greater administrative cost and burden. Every year that it's open, the trustee has to file a separate tax return for the trust, and income generated by assets inside of the trust are also taxed at the trust tax rate.
So you mentioned the Secure Act, which we've talked about, and that is something that when it came out, there's some changes that can and or should be made to anyone who's watching perhaps a trust that would be covered under the Legacy Protection Program. But maybe you can talk quickly and briefly about that, what they should be considering when it came to the Secure Act.
So if you created your trust before January of 2020, which is a lot of people, your language inside your trust as it relates to retirement accounts is likely outdated because it's not in compliance with the Secure Act. The Secure Act, in essence, kind of narrowed the window in terms of how long people can have to take out distributions from retirement accounts. In the past, it's over a life expectancy based on the life expectancy chart. Now it's 10 years for most beneficiaries. And then so that's a pretty big change. And it would be really prudent, I think, on behalf of the clients to update their trust so that at least the language in their trust is in compliance with the law.
So it's something you've done, you guys have all done, I guess, over the course of the last 12 plus months or whatever it may have been, that you can just make modifications, an amendment to your trust, right?
Correct.
Okay. All right, Kevin, when do you recommend a living trust and what factors trigger that recommendation?
Sure. If I could roll back real quick to what I said earlier, I said if a trust had needed to have $600 or more in it to file a tax return, what I should have said that it requires the trust needs to accrue $600 in income for that year to file the tax return. So, so back to what you were just saying though, so whenever you're talking about whether you want a living trust or not, that's kind of up to the client, I think, and what they feel is most important to them. So if it's really important to them that they don't have their loved ones dealing with probate court after their passing, then I think that revocable living trust is a great option for them. Or if they just want to have a little bit more control over than what the will can, than just a will can provide, I think that would also be a time to look at it.
And I know there's some information on the TuckerAllen website, kind of walks you through step by step in terms of what you think is something you may be interested in or need or what applies to you. I encourage people to go check out the resources on the webpage. I know you all have devoted a lot of time to try to just make this simple where you can get information about what steps you should take, what is appropriate for you before you even have that first conversation with an attorney. It's free. Just go online, check it out. Wonderful resources available, especially during COVID. You may not want to leave. You may not want to make that first phone call yet. So check it out. Thanks, Kevin. All right, Missy, question came in. I have a special needs trust, which will be used for my permanently disabled sister who is in a nursing home. Much of my retirement savings are in a 403B that I have not had to use for myself. Are there any special issues or problems my trust should be aware of, or my executor of my trust, regarding use of those funds in the future for my sister?
Sure. So I'm assuming that your 403B directs the beneficiary to be the special needs trust. So that's kind of framing my answer there. If you did some other way, then this isn't going to apply, but that's usually how that would work out. Any money that goes into the special needs trust needs to be spent on your sister in a very particular way in order to keep her on her government benefits, which I'm assuming she has if she's permanently disabled. Chances are she's receiving something like Medicaid to help take care of her in the home.
So let me ask you real quickly before you go on. I know there's more. We talk about special needs trust and we throw that out there like everyone knows. It's something TuckerAllen does. What is that really quickly in a definition?
Sure. So a special needs trust is a trust that's set up to for the benefit of someone who is disabled that complies with all the various laws around government special benefits for people that are disabled. So Medicare is the biggest one. There are a bunch of rules that Medicaid puts out about how much money this person can have in order to still continue to receive Medicaid benefits for their food, shelter, and medical care. So if they just got this money outright, the government would take that money back in order to offset their care costs. So putting it into a special needs trust means that they can receive the benefit of this inheritance without being kicked off of Medicaid or whatever their government needs assistance is.
Got it. And I know I interrupted you. So issues with the 403B in using it for the sister or what, that's I think where the last question was for that person.
Thanks for the reminder. So the special needs trust money cannot be used for things like her rent or her fees for staying in a nursing home or for food. These are all things that the government is going to provide through Medicaid. It can be used for things like home furnishings, Netflix subscriptions, therapies and education that aren't covered by Medicaid. If she can drive, then having a car would be covered. All kinds of things like this that they can spend a lot of awesome enrichment activities on that aren't food, shelter, and other necessities.
Got it. All right, we just have a few more minutes for questions. So if you've got a question, get those in now. You can use the Q&A section, or again, you can send those to tuckerallen.com/questions. We'll address those at Tucker Allen Live on Fridays, 1 o'clock Central Time, just 15 minutes. You can tune in. Check us out across all social media, but go ahead and follow us on Facebook. You'll be alerted when we go live on Fridays, and you can find out the topic. It's real quick, real fast, just a real quick answer session about a particular topic when we're talking about wills and trusts. So let's go to Teresa. When refinancing our house, I was uncertain whether to use our trust as the technical owner of the home. Just want to make sure that if something were to happen to me and my wife, that all assets are moved to the trust. So for me, as I'm thinking, maybe it's a couple part question is it okay? Or is there a better way to do it?
I mean, technically it's okay. You can certainly do that, but we would normally recommend that if you still are kind of actively working with your house, like paying off a mortgage, especially if you're refinancing it, then I think the kind of easier solution and better solution would just to have it set up that for the trust to be the beneficiary rather than to be the owner of the house right now, just because as soon as the trust is the owner, you can still manage that house as but you would be managing it wearing the hat of a trustee rather than as an individual. And really, it's just easier to have it be the beneficiary. For other people who are listening, if you already own a home outright and you want to create a trust, oftentimes we just have the trust be the owner of the home.
And I know sometimes when you're either purchasing a house or refinancing, lenders tend to flip a little bit when you're trying to put it into a trust. It seems to me, at least my experience, they get a little, I don't know, edgy when you're saying, and then they want to see the whole trust and you try to give them a part of the trust, and so I assume that's some of the complications that people should be considering as well.
Yeah, so those are just like practical complications and maybe headaches you can avoid, and the better solution is just have the trust be the beneficiary anyways. But I think the takeaway is, okay, the trust is not the owner when you refinance your house, but remember, if you acquire property later on, if you buy a house later on, like make sure the trust is the beneficiary still. You want to make sure there's a beneficiary in the house.
Got it. All right. Last question I have, Kevin. Can you exclude one of your children from benefiting from your estate? And if you can, let's talk about maybe the cons, what can happen, are there challenges? Kind of walk us through whether you just can and what happens if you do.
Sure. So you absolutely can exclude a child from benefiting from your estate, but there's going to be a lot of potential issues in this. So there's the state of Missouri here, we have a statute that kind of allows for maybe a child to claw back some of that unless they are, unless it's written down that you're excluding this child. So if you just don't put them into your estate plan at all and they get nothing, then they can kind of claw it back unless you put into your estate plan, nope, there's nothing for this child. It can create some issues unless it's done correctly.
Yeah. Obviously, you don't want to just go do it without consultation with an attorney to make sure you do it right. Like anything, I mean, especially when everything's on the line and everything you've worked hard for, and you want to, follow the instructions. Make sure you consider your options. You consider the pros, consider the cons. Make sure that you're covered. Obviously, as you suggest, if you're going to do it right, and make sure it's legally tight and appropriate. So. That is all the questions we have. Let me just check one more. That's it. So thanks to the panel for joining us today. As always, we appreciate your input. And if you have questions, you can reach out. Give us a call. You can give us a call at 866-335-3375 or visit us online, TuckerAllen.com. As I said earlier, submit your questions. If we didn't get to them today and you just thought of something, you can get to TuckerAllen.com/questions, or tomorrow and every Friday, 1 o'clock Central, Tucker Allen Live on Facebook. You too can also submit questions in the comment section. We'll get to those. 15 minutes. We always end on time. We don't go over. We want to make sure we understand you appreciate what you have going on. We figure 15 minutes is good. So check us out. Follow us on social media as well. Check out all of the information we alluded to earlier on the website. Walk you through the steps, the things that you need the choices you have to make, and kind of educate you as well. There were a lot of questions about the Legacy Protection Program. You can find that as well on the website, or give them a call. You can schedule a consultation via Zoom, in person where appropriate and where allowed. We want to make sure you feel comfortable, safe, secure. You can have that conversation right from where you are right now at home. You can practically get most of it done. I know in Missouri that they've made some accommodations with notary and those types of things to start doing things remotely, which we take a look at COVID and we turn it into a positive. And that's a good thing that's happened as a result of it. So continue to tune in to our town halls that will continue forward in 2021. And also, again, TuckerAllen Live on Facebook. Check us out. So until next time, thanks for tuning in and have a great rest of the week. See you next time.